Thank you. We will reconvene and we now will be hearing from Federated Farmers. So good morning, welcome. Good to see you here in person, both of you.
Good morning. Thank you very much for the opportunity to present this morning. My name is Rachel Thomas and I'm a Senior Policy Advisor with Federated Farmers. And I'll firstly hand over to my colleague, Miss Cook-Munro, who's online.
Good morning all. My name is Joanne Cook-Munro and I am Legal Counsel for Federated Farmers based in Hamilton. Thank you for the opportunity to appear before you today. With me today, as you already know, Miss Rachel Thomas and Ms Bernadette Hunt. Ms Thomas is a Senior Policy Advisor with Federated Farmers and she is based in the South Island and lives and works on the family farm. Ms Hunt has an extensive farming background and is a current member of the Southland Provincial Executive for Federated Farmers. It is submitted to the hearings panel that these submissions be dealt with as supplementary legal submissions. This request is based on the following reasons. The process used for this hearing is flawed and has given certain parties an advantage over other parties through their ability to provide additional supplementary evidence. There has been a significant amount of additional information lodged by the Council and the Runanga since the beginning of February 2025, an additional 5 sets of documents from both parties. The supplementary evidence that have been lodged by the Council and the Runanga have contained significant amendments. For example, the supplementary evidence received from the Runanga on February the 12th was 125 pages in length and contained substantial detail which needs to be examined. There has also been insufficient time provided for submitters to analyse and respond to the additional information circulated. We believe that an uneven playing field has occurred due to the process that has been allowed to occur with multiple additional information being circulated. This continued circulation of additional information and new information continued up until 5:02 PM on February the 7th, when the Council's planner filed her supplementary evidence. The continued circulation of new information has been detrimental to Federated Farmers in that there has not been time to undertake a detailed consideration of the new information. As well, the circulation and consideration for this hearing has encroached into the timetable set for other topics being heard for the proposed district plan. Federated Farmers of New Zealand, Southland Province, has played an active role in the proposed district plan process. It has made submissions and further submissions to the SASMS chapter of the PDP. It has worked with the Runanga in order to understand better what their concerns are and what the appropriate way of addressing these could be. If given the opportunity in this proposed district plan process, the Southland Province would welcome the opportunity to continue working with the Runanga. It needs to be made clear that the Southland Province does not oppose what is trying to be achieved, with the amendments proposed and the introduction of the Ngāi Tahu Cultural Values chapter. What it is opposed to is how it is being done without all parties being treated fairly and having the ability to respond to the amendments as they have been proposed. The province also seeks the recognition of the importance of farming to the Gore district, and it has felt that the way the proposed district plan process is being handled does not and will not achieve this. The process in respect of the SASMS chapter has already been made unnecessarily difficult by the Council. This issue has been addressed in the legal submissions submitted on behalf of the Southland Province on February the 5th. Note was also made of the fact that Council itself has acknowledged the difficulty in its Section 32 report. The Southland Province stands by the original relief it has sought and formally requests that the withdrawal of the SASM/Mana Whenua and Ngāi Tahu Cultural Values chapters are withdrawn and an appropriate Schedule 1 RMA process is undertaken. In its previous legal submissions and evidence, the province sought alternative relief if the hearings panel was of the view that it would not withdraw. the chapters as requested. Given the extent of the new information that has been circulated and the lack of time provided to review this information in detail, the province's preference is for the relevant chapters to be withdrawn and notified as a variation to the proposed district plan. If the alternative relief is pursued, then the province requests that sufficient time is provided so that it can review the proposed amendments and make informed and detailed comments on those amendments. In our original legal submissions, we outlined our perspective on the issue of legal scope. With all due respect to my learned colleagues and their supplementary legal submissions, we do not agree with the conclusions that have been reached on behalf of the Runanga and the Council. It is submitted that what has been proposed by the Council is outside the scope that it has in respect of the proposed district plan process. The proposed amendments do not meet the legal test set out by the High Court in the Palmerston North City Council and Motor Machinist Limited case. The proposed amendments seek to alter the structure of the proposed district plan from that which was notified, as well as introducing new information. The proposed amendments seek to delete the SASMS chapter, which is a chapter relevant to the proposed district plan. I note that the supplementary legal submissions for the Runanga state that the notified SASMS chapter identified the entire core district as a site of significance. So the Council considered that the SASMS chapter was relevant to the district when it notified its district plan. Unless there has been a submission that directly asked for the SASMS chapter to be deleted and replaced with the cultural values chapter, it is submitted that the Council does not have the ability to change its mind, that the entire district was a SASM after the submissions process has been closed and the hearings process has commenced. This in itself is a significant change to the position put forward in the notified proposed district plan. It is also entirely possible that a person who did not originally submit on the provisions of the notified proposed district plan would have submitted if the proposed district plan had contained the proposed Ngāi Tahu Cultural Values chapter. This introduces a real risk that there is a person who may be directly affected by the proposed amendments who have been denied an opportunity to respond to what the proposed amendments seek. It would not have been reasonably foreseeable to other submitters that after the notified proposed district plan referring to the core district as a site of cultural significance, that the PDP would then be amended on the grounds that there are no sites of significance to Māori. Having reviewed the submission made by the Runanga, it is noted that the Runanga supported all the provisions in the proposed plan as notified, except for the amendments it sought. The submission did not seek any relief related to the SASMS chapter. The submission did seek the amendments to references to the Ngāi Tahu values to include a more detailed description of the particular effects to be avoided, remedied or mitigated. The submission by the Runanga did not specifically seek the deletions of the SASM chapter, nor did it indirectly seek the deletion of the chapter. While acknowledging that the Runanga is best placed to decide how to manage the effects on the Ngāi Tahu cultural values, this does not provide the legal scope to do what has been proposed. In respect of the legal submissions made by Ms Chadwick on behalf of the Council, it is agreed that the Ngāi Tahu Claims Settlement Act is relevant. It sets out the specific requirements that must be met between the Crown and Ngāi Tahu. The appropriate statutory acknowledgement has been included in the RMA as required, which means decision making in relation to statutory acknowledgement is subject to Part 2 of the RMA. The Act also specifically sets out what the purposes of the statutory acknowledgements are, none of which, it is submitted, provide legal scope for the amendments to occur outside of the usual RMA process. However, it is respectively submitted that there is no legal scope. The amendments form part of a resource management process Council is required to follow the statutory process set out in the RMA, as well as the established principles from case law. Also, in respect of the legal submissions by Ms Chadwick, it is respectfully noted that our original legal submissions did not disagree with the principles defined by the High Court in the Albany North case. It was submitted that the case should be distinguished from the present situation and care should be taken in the application of the case. The case involved a non-standard process undertaken under the Local Government Act that had been specifically developed for the transition of the cities within the Auckland boundary to become a unitary authority. It was not a statutory RMA process. The Local Government Auckland Transitional Provisions Act also set out the statutory duties of the hearings panel, as well as the process for the development of the first combined plan for the Auckland Council. The panel was required to make its decision under the Transitional Provisions Act. The Act also defined the appeal rights for the process. It is submitted once more that the hearings panel in these proceedings fall within the mandate of the RMA, and as such are required to follow the Schedule 1 RMA process, as well as making decisions consistent with RMA precedent. It is considered that there is no legal scope for the proposed amendments to be made, and that the amendments go beyond what is reasonably and fairly raised in the submissions on the proposed district plan. In summary, for there to be scope to make an amendment to a plan change, the two-limb test set out in Motor Machinist must be achieved. Any amendment made following notification must be fairly and reasonably within a range of options between what was originally notified and the relief requested in submissions. It is submitted that the proposed amendments are not fair and reasonable and would not have been able to be anticipated. In respect of the National Planning Standards, we respectfully do not support the legal submissions made by Ms Chadwick. The National Planning Standards set out clearly what the mandatory directions are for district plans. Part 4 sets out the mandatory directions for district plan structure. Direction 1 requires that all parts in their titles and Table 4 must be included in the order shown. Direction 2 requires all chapters and sections shown in black in Table 4 must be included in the order shown. Unless otherwise specified, all chapters and sections in grey in Table 4 must be included if relevant in the order shown. Direction 3. Given that the notified post-district plan contained a SASMS chapter, it is logical to believe that the chapter was considered relevant at the time of notification. To then propose the deletion of that chapter at the hearings phase appears contrary to the starting point for the proposed district plan, which was that all of the district was considered to be of relevance and significance to tangata whenua, mana whenua. As well, in the supplementary legal submissions on behalf of the Runanga, it was noted that the Runanga considered all whenua and wai within Gore District to be important to them. This statement is at odds to a previous statement made in legal submissions, which essentially dismissed the need for a SASMS chapter and it not being relevant, as the Runanga did not propose to identify specific sites within the district. It is the Council's responsibility to decide if the inclusion of a SASMS chapter in the proposed district plan is relevant. The Runanga can recommend which approach it prefers for the district, but ultimately the Council is required to meet the requirements of the RMA and the National Planning Standards. Given that the operative district plan contains 6 scheduled archaeological sites of significance to Māori, which have been transferred into the proposed district plan as Schedule 3 of the Historic Heritage chapter, it is apparent that there are sites of significance to Māori located in the Gore District. Part 7 of the National Planning Standards set out the mandatory directions for topics such as historical and cultural values. Direction 17 lists what must go into a SASMS chapter if those matters are addressed. I propose not to read that out, as I'm sure the hearings panel is very familiar with that direction. The direction is very clear about the matters that address sites and areas of significance to Māori and where they are to be located. Direction 18 in Part 7 of the National Planning Standards states that any additional chapters to address other historical and cultural values on a district-wide basis must be included alphabetically under the historic and cultural values heading. This means that the proposed Ngāi Tahu cultural values chapter should be located under this heading and not as a standalone section as has been proposed. It is submitted to the hearings panel that the SASMS chapter is relevant to the Gore district and its proposed district plan, as there are scheduled archaeological sites of significance in the notified proposed district plan. The proposed Ngāi Tahu cultural values chapter can be introduced into the proposed plan as provided for by the National Planning Standards, but must not be used to replace the SASMS chapter, which Federated Farmers contends is of relevance to the district. In conclusion, we submit that there is no legal scope to make the proposed amendment sought by the Council and the Runanga. It is requested that the hearings panel should consider how the lack of clarity and confusion that arose from the notified SASMS chapter has impacted the ability of parties to submit on the proposed alternative relief. The lack of clarity increases the likelihood that any further amendments will result in the plan ending up in a form which could not reasonably have been anticipated, resulting in procedural unfairness. The relief sought is that the relevant chapters are withdrawn and that a plan variation is notified that meets the requirements of Schedule 1 of the RMA. It is also requested that the Council involves the relevant parties to this hearing in the determination of the proposed content of the variation. If the hearings panel is not of the mind to grant the relief outlined, we respectively ask that Federated Farmers remains involved in the development of any alternative relief between the Council and the Runanga to give effect and hopefully an acceptable compromise to all parties to deal with SASMS and Ngāi Tahu cultural values within the Gore district.
Can I just check, do we have a copy of your supplementary statement that you just read out?
I will be sending it very soon to your administrator.
I reckon it would be really helpful for me, particularly before we get to questions, because I'll want to work through, like I've been making notes as you've been speaking, but it would be so helpful when I ask the question that I can go through and tie it actually to the, that would be really helpful.
I'm wondering, as an alternative, that so we've had conflicting legal advice given to us now, and there's probably a third consideration that we need to take into account. So I'm wondering, when we come back from lunch, if we can actually address the issue with all three solicitors present and hear the legal submissions from Hokonui Runanga, and our questions then are probably questions that we can seek from all three. But yeah, Joanne, will you be available after lunch, and we'll work out the best way of posing the questions. What Commissioner Bartlett just highlighted was that she wants to put some questions to you before hearing from the Hokonui Runanga.
Okay, I will make myself available to the panel.
Right. So when we come to, we'll come back to you as to the likely start time after lunch. I'll get the admin team to send you an email. If we were to accept your advice, this panel doesn't have the authority to prepare a variation to the plan, and if we're to recommend it to the council, there can be no guarantee that it would proceed. So there's a risk if we reach that view in terms of proceeding further. Is there anything else you want to add with regard to the variation process?
I'm very much aware that it will ultimately be the council's decision on how to move forward on this issue. However, I would like to note that given the process that has been used, the large amount of information that has literally been flying about in the last 5 days, the confusion that occurred at the start of this proposed district plan process, that it would be in good faith for a variation to be done and to remove confusion, to come to a solution that is acceptable to all parties, and to be able to move forward positively in the Gore district in respect of SASMs. At the moment, the process has been very confusing. The intentions of the council have been very confusing, and there just has not been enough time given to other parties to be able to analyse the large amounts of information that have been sent out in a short period of time.
In the alternative, might you want to ask us not to have regard to the material submitted in the last week?
I believe a lot of hard work and a lot of long hours have occurred with the information that has been circulated in the last week, and that information does deserve to be considered. What I'm trying to highlight is submitters such as Federated Farmers did not have an equal opportunity to be able to review and analyse that information.
The other point you raised was with regard to the content or showing sites and areas of significance to Maori. As part of the heritage hearing, we received technical advice that a number of the archaeological sites listed in the plan did not meet the standard in terms of the certainty of information to justify their inclusion in the plan. And from a legal point of view, what avenues are open to us that could require the Hokanui Runanga to actually provide information on sites and areas of significance to Maori?
Very well considered question. I do not believe legally the Runanga can be forced to provide the information. However, I do believe there are other alternatives. Other iwi that I have worked for and with in the Waikato have used silent files. So there's been a very generic description in their district plan and notes made in the SASMs chapter, but the actual details of those sites are on a silent folder, not available to the public. It's just an indication as more like an area shown on as a SASMs overlay. For example, there may be a PAR site, but what is shown on the planning maps is an area that can incorporate a buffer zone of 1 to 5 kilometres, and that's usually been agreed in conjunction with the landowner. So they try, in the Waikato, we are trying different options to see how they can still protect their sites but still be effective in participating and providing certainty into the district plan process. And I'm not saying that one size fits all. I do realise that there will be different circumstances for each iwi and each hapu.
Thank you for that. I guess another option with regard to your concern of not having sufficient time to consider the latest evidence come in, and that is the option of inviting the submitters present, which would be Federated Farmers, to do a written response to that material within a time frame. What is your view on that?
While I'm sure Federated Farmers would appreciate that opportunity, I'm also aware that we have evidence due for another hearing by the end of this week. And for myself personally, I dip into an all-week court mediation starting next week. So while the time would be appreciated, it goes back to what I referred to in my legal submissions. It's starting to encroach on our ability to participate effectively in other areas.
And just to highlight for the panel, this is our third continuous week out of 5 in a row where we're having hearings and deliberations. So I understand where you're coming from. So if that's the end of your legal submissions, we'll go back to Rachel in terms of other matters you want to cover.
Thank you. So I will take this opportunity to highlight some of our key points from our evidence and respond to the supplementary statement of Ms Amy Buran, which was released since the lodging of our evidence. I firstly wish to raise our concerns regarding process. The splitting of the SASM hearing across December and February has resulted in a favourable outcome for Hokonui Runanga and the Council, but less favourable for some submitters. While it was Federated Farmers that requested this delay, we did not anticipate there would be multiple opportunities for both Runanga and the Council, and not other submitters, to provide evidence, legal submissions and rebuttal evidence. For submitters, there has only been one opportunity. Federated Farmers lodged advocacy evidence on the 29th of January 2025 and legal submissions on the 5th of February. Council lodged a statement of supplementary planning evidence on the 4th of February. Hokonui Runanga lodged a supplementary legal submission on 11th of February and on 12th of February lodged a supplementary planning statement. The Council lodged its legal submission in response on 14th of February. There has been no opportunity for submitters to lodge additional supplementary evidence, despite the breadth of changes which have been put forward by Ms Buran's 125-page document. Council was also due to release an additional Section 42A statement on the 17th of February, which was received after 5 p.m. In my view, the panel has been accommodating of submitter requests throughout the PDP process, and we are thankful for this as we have benefited from this approach on multiple occasions. However, with regards to the SASM hearing and the breadth of information released, particularly within the last week, there has not been adequate time provided for submitters to review all relevant material before today's hearing. A clear example of this is Ms Buran's supplementary evidence of 125 pages. Ms Buran includes specific word changes which, if accepted by the panel, have not been subject to wider feedback from submitters. The submitters who have had the opportunity to review these, ourselves and Transpower, have not been given the opportunity to submit additional written evidence addressing these changes. Ms Buran identifies an issue with the proposed district plan, which she terms a mixed approach to including Ngāi Tahu cultural values related provisions throughout the notified version of the proposed district plan. There is almost a 50-50 split between the chapters where Ngāi Tahu cultural values related provisions have been integrated within the chapters and scenarios where there are clear gaps with Ngāi Tahu cultural values provisions not being integrated. This anomaly within the PDP signals the Council should not pursue the plan in its current form, and I question whether the Council has scope to make such widespread changes at this stage, but defer to Ms Cook-Munro. Ms Buran states, I consider that a broader plan-wide analysis of the PDP needs to be carried out by Council's Section 42A reporting officers or a lead planner for the district plan review. Federated Farmers agrees with this statement and requests involvement in any process going forward. I am at this point reminded of comments made by Gore District Council councillors at the December meeting last year, where the plan process was called a mess, an absolute embarrassment and an absolute cluster. Turning now to the matter of values within the plan, it is important to clarify that Federated Farmers is not opposed to the recognition of cultural values in decision making. Our priority is ensuring that the plan captures values in a consistent way to give plan users, council and mana whenua certainty over when values apply to particular activities. Ms Baran, within her supplementary evidence, provides a table included as Appendix G, which identifies potential concerns mana whenua may hold with plan provisions. At paragraph 108 of our evidence, we suggested including a table in the PDP which sets out cultural values by activity. The table presented by Ms Baran effectively achieves this and would be beneficial to include alongside relevant plan provisions. Ms Baran proposes the deletion of utu and te reo Māori from the PDP. While Federated Farmers have not provided specific comment on which values should be included in the PDP, as that is up to mana whenua, we did struggle to see how utu or te reo Māori would apply to assessing resource consents. Ms Baran proposes the addition of wahi tapu and wahi taonga. Wahi tapu relates to the proposed NTCV 01 and NTCV 02, and as per Ms Baran's explanation, are sacred sites or areas held in reverence according to whakapapa. Within our evidence, we sought the identification of known sites. The addition of wahi tapu as a value could support the identification and mapping of wahi tapu sites. Ms Baran's statement proposes the addition of tino rangatiratanga, yet there is no discussion on why this value is proposed, and it does not feature within the table provided at Appendix G, which assesses values against activities. As the PDP does not specify which values apply to each activity, we do not support the inclusion of tino rangatiratanga at this stage in the plan process. Federated Farmers has developed a good relationship with Hokonui Runanga through the establishment of a working group between the parties. This working group has been mutually beneficial, with both parties gaining a better understanding of each other's position. Federated Farmers does not wish to question the association of values mana whenua hold with land within the district, but strongly believes that an absence of site mapping will be detrimental to the protection of known sites or areas that are of greater significance. We also question whether the relief sought by Hokonui Runanga will achieve the relevant provisions of Part 2 of the RMA. The proposed approach is highly ambiguous regarding the time, consultation and cost of lodging an application. As stated in the legal submission for Transpower, there are real-world impracticalities and inconsistencies with the relief sought by Hokonui Runanga and also with the notified PDP. Hokonui Runanga are likely to receive more requests from applicants prior to lodging applications when purchasing properties, and from the council, who will likely take an overly cautious approach when determining if cultural assessment is required. This will cause an increased need for greater resourcing within the Runanga, with costs passed on to resource consent applicants. To summarise, our preferred relief is a legal matter based on scope, as canvassed by my colleague Ms Cook-Munro. The alternative relief we seek is set out within our evidence, but relates to amendments to the SASM chapter, a commitment to map known sites of significance, inclusion of a future work policy on site mapping, and amendments to the mana whenua chapter. We are seeking an outcome for our members which is fair, provides certainty over land, does not erode private property rights, and ensures adequate protection of cultural sites. I'll now hand over to Ms Hunt to provide another perspective.
Just before you continue, what you were reading from there, will you also provide to us?
Yes, happy to do so.
And if you're connected, can you email us them now?
Yep.
Yeah, and that way we...
I suspect what we might be doing is taking a slightly longer lunch so that we can read through
Yeah.
what has just been read out. But let's see how we go.
Yep.
Sure. I just want to make two kind of overarching comments before opening for questions. So firstly, as a lay person representing farming members, I'm really fortunate to have the support of the two ladies you've just heard from to navigate this process and help keep me abreast of the developments. But despite this, I'm feeling completely overwhelmed at the constant stream of information. and very long documents. Every one of those documents takes a lot of wading through and is often closely followed by a new deadline to respond, which has been discussed. And I note the feedback from the people that are working full-time on this, saying that they just aren't managing to be able to work through that info and respond in the timeframes, and that's just for the SASM's chapter. Across the plan more broadly as a federation, we've had to choose which chapters we focus our efforts on and hope that others are picking up the detail of the ones we can't get to. So, how is a resident or ratepayer supposed to genuinely participate in this process? And given they're the ones most affected by the outcomes, surely their participation is vital. What this is turning into is a plan developed by a group of people who mostly don't live locally and are ultimately unimpacted by the outcomes. Is that what you're aiming for? Because if it isn't, I really think you need to carefully consider the next steps and timeframes for this plan. The reality is that in real terms, this process, not just for the SASM's chapter, but for the whole plan, has now shut out the majority of the local community. And that means that Gore District Council isn't meeting its obligations under the Local Government Act or meeting our expectations as ratepayers and residents, and I think that should be a real concern. More specifically regarding this chapter, I just want to provide one general overarching comment. As a farmer representing myself and other farming members, and as a federation, our key concern is the overarching need for land use flexibility, and where that flexibility might be inhibited, a clear understanding of where and how. We understand that it's not reasonable to do whatever we want, wherever we want, whenever we want, because sometimes actions and activities can impact other people. However, we do need to understand what the limitations are so that we can plan around them and work towards them, because that planning is often decades ahead for us. To give an example, we personally are currently looking at farms for sale and looking to purchase. As we weigh up the pros and cons of different options, we consider how each one may allow us to implement our 10 to 20 year dreams and goals as a farming family. Having access to some level of information about anything that might inhibit that is vital. On the properties we already own or farm, we're constantly considering how we make gradual shifts towards those dreams and goals for our family to adapt to things like changing climate, market demands, new opportunities. Again, understanding the limitations on the property will stop us shifting in a direction that was never going to be the right place to take that property. We don't necessarily need the specific detail, but we do need a reasonable indication that gives us confidence to make plans and move forward. Telling us that the whole district has significance and that there are a list of activities which may require cultural assessment to determine whether a resource consent can be provided doesn't feel to us like a reasonable indication. From where we sit, that's like buying a multi-million-dollar lottery ticket. We buy a farm with some specific plans in mind for it, only to find that when we pursue those plans in a bit more depth, they were never going to be able to go ahead. The way the plan is written, the only way we can see through that is that we contact Runanga for every property we view and ask them to consider if there may be a restriction. And then we wait for the response, which may or not be available in the property sale timeframe, often which is quite short, and which, without more detail about our plan, isn't actually likely to give us much security anyway, as by the time we get to a resource consent stage 10 years later, that initial advice probably won't carry much weight. Play that out for every person looking to purchase or lease farmland, and every landowner who might want to alter their land use or undertake development in the future, and also bearing in mind that we don't know what activities may require a resource consent in the future, because it feels like that list is ever increasing. It's just not realistic. So hopefully this helps you understand why farmers have concerns. It's not racist, as some might be trying to imply, not in this space. In fact, it has nothing to do with the fact that this is about cultural significance. It wouldn't matter what the uncertainty was around. If it has the potential to impact on land use flexibility, we just need to understand what and how, so that we can undertake reasonable due diligence before we progress any investment decisions. I and we as federated farmers don't think that's unreasonable, and that's why farmers are feeling and expressing so much concern and frustration over this plan and this chapter. Thank you. Open to questions for the Federated Farmers Group now.
Yeah, kia ora. So I just want to pick up, before we do anything else, just on that last portion of your statement there, Ms Hunt. So when those concerns around land use flexibility, where and when things can happen, which was at the core of what you were just outlining, that have either of you had a chance to have a look at what I think was the Section 42A officer's attempt to respond to those kind of concerns from submitters, which was the Appendix C, which was basically, so in Appendix C, it's outlining all the permitted activities. There's a whole column of permitted activities, and there's only one where Ngāi Tahu values come into play. So all of those permitted activities have parameters around them, so that's quite a lot of certainty around you can go ahead, you can do all of that stuff, you just don't need to worry. And it's only if you're outside the parameters of those permitted activities, so none of the permitted activities in that analysis that she's given us, none of those permitted activities refer to Ngāi Tahu cultural values. So you can do a whole bunch of stuff, like as per that table, and then it's only if consent is required, and then you head into the far column of that table, if consent is triggered, then it's either going to be controlled, restricted, discretionary, or fully discretionary. If it's controlled, you'll only consider Ngāi Tahu values if it's a matter for control or a matter for discretion. So what I'm trying to say is that in terms of certainty, the certainty is provided inside the permitted activity framework, and then if a resource consent is triggered, there'll be a bunch of matters that need consideration, and only sometimes are Ngāi Tahu values included in that consideration. So does that help in some way? For instance, if you were looking to buy a property, if you've got this whole suite of things that are permitted and you look at those, that can give you some confidence of just proceeding. It's a way to, that the plan at the moment is recognising a whole bunch of uses and support for those uses. So maybe that wasn't understood from the material, and have you had a chance, either of you or both of you, to look at that, which was a response to this concern, I think.
I can just provide a general lay comment, and then Rachel can probably go a little bit more to the detail of what's, you know, specifically in the document. But as a general comment, one thing I've experienced in, you know, our 18 to 20 year farming history is that over time, what is permitted is narrowing. And so my concern as a layperson is that this process, then it may not be the right specific planning word, but this process of cultural assessment for activities that require a consent, while it may be more acceptable, you know, at the moment based on what is permitted and what is not permitted, the concern is what's going to evolve in terms of what requires a consent in the future, and that this process would, as the permitted activity list potentially reduces, which may not be under the control of the council, it often comes from government level, how does this then, you know, that list of things that it impacts can grow. So I'm not only thinking about what is permitted now, but I'm thinking about how as restrictions on land use evolve, this, you know, and as an example, and this is not a Gore District example, but as an example, you know, with water quality, for example, there were initially good management practices around fertiliser use, then that became guidance around some limits, upper limits, and then that has now become a process where lots of things are no longer permitted. So that's kind of one example. So that, yeah, but Rachel could probably comment more specifically from a planning perspective.
So the first thing I would say is that we've got control now on this plan, and this plan, aside for any reviews or what have you, you know, the life of it until a mandated or required review, you know, is 10 years. Things can happen, as you say, with national direction and things like that. We don't have any control over that, but we can control what the plan achieves now. Yeah, and we'll do that with all of the voices. And we've obviously had a lot of submissions in farmer voices. They're all there to guide the decision making for us. So that, I think, is the benefit of having all of those voices in this process.
Yeah, I'll just add to that. So I have reviewed Ms Bennett's Appendix C, and I completely understand its intentions. I initially didn't, because I didn't see any relevance to counting the number of matters of discretion, and I still think that's perhaps not a detail that's needed. What is important is that cultural assessment is a matter of discretion under those activities, and it has the potential to delay resource consent applications, to significantly increase the cost, and also just provide so much uncertainty as to what farmers can do. So thinking back to Ms Hunt's example about purchasing a farm, I am a farmer myself, and when we have in the past looked at properties as well, you think about the future potential, and you think about a conversion that you might want to make, and you need to know if you're going to apply for a cultural assessment, what that might entail and what that might reveal. So having knowledge of known sites and known things that have happened on the land, or known areas of the land that need to be protected or recognised, is really important for farmers, because farmers want to do the right thing by the land as well.
What role do you think the iwi management plan that's already a live thing in the district can assist their understanding?
I don't have a great knowledge of the iwi management plan in the district, so I'm not sure if Ms Monroe wants to share anything.
I guess what I'm saying is, like, there is an iwi management plan that's been in existence since 2008, 2009, can't remember which, and it covers the whole of the Southern District, including Gore. So it's quite a big document in itself, and contains, it's referred to in this plan as a guidance tool. So I guess what I'm suggesting is that there's no guidance, and I just wanted to test whether the existence of that guidance was helpful from a farming perspective.
If farmers are able to interpret the iwi management plan, then yes, but I think the district plan should be the place that they go to find out what is possible on their land, and having to get cultural assessment for a range of activities is not a reasonable approach for them.
In practice, how does what is in the proposed plan differ from what is in force now?
I will probably have the same answer as the planner from Transpower, in that I don't have a great knowledge of the operative plan at the moment, but the national planning standards have come in, obviously, in the past 20 years, and so there's a different framework within which we need to be working. And I mean, we're already seeing that with references to sites of significance in the RPS as well, and other documents which have been raised through legal submissions, that this is the framework, and the majority of councils that we are working with are mapping these sites.
We now think you have a hard copy of what you've said, and we will have a look at that. Any further?
Oh, I've got one question, because I picked it up in your initial statement. So when Commissioner Havell was asking legal counsel, would opportunity to provide a written reply be welcomed? And when I was hearing you speak, it sounded like that maybe that would be welcomed, depending on the time frame for supplying the written reply. Because I guess my reason for asking that is responding to your concerns around what's occurred as a result of the split in the process, and so an opportunity for written reply given those time constraints. Now, those time constraints were a matter of just the scheduling difficulties of splitting the hearing, right? So that's affected all of us participating in the process in a similar manner. We're all squeezed quite badly. So, but we're all endeavouring to still achieve our mission. So if the opportunity was provided to respond in writing, would you accept that offer?
I think the relief that we're seeking is quite clearly stated in the legal submission that Ms Cook-Munro presented this morning, which you'll have a copy of shortly.
So you don't want the opportunity to write a written reply?
In her relief, she suggests that we're involved in the development of any changes going forward, because it's, I mean, I appreciate there's a time delay, but that, you know, these are things which impact farmers, and so we've been involved in the process to date, and we'd like to.
So let's put it this way: if that was the only way that you could have a say, because we're going to work with the material that we've got to make our decision, if the only way to do that at this point was to put in a written response to the material so that it's on record and we can use it in our decision-making process, would you want the opportunity to do that?
Yes, we would, if that was the only option available, and sufficient time, bearing in mind there's evidence due Friday and more hearings coming up as well.
And also bearing in mind the ability of us to actually issue a directive, given all the other reading material that we have, as demonstrated by a minute that was issued this morning in relation to Stony Creek. So, you know, the volume of paper that we have, I hear the messages coming through. We have the same issues as yourselves in terms of coming to grips with it, and it may well be, given our desire or acknowledgement that the time frames to issue decisions and work through the detail, we need to find something that is both fair but also efficient and effective in terms of reaching an outcome. Anything else? No. Rachel, at paragraph 111 of your initial statement, you picked up on the point that I asked a question about this morning of reference to decision making in some of these policies. So are you happy now that with the response that was given?
Yes, I was. Yes, thank you.
And also with regard to existing use rights, in the very first hearing I think you were present at, where we had a discussion that it isn't appropriate for us to identify and overstate existing use rights, but that should be acknowledged as part of the initial introduction to the plan and how the plan works. Right, because if you had it in one chapter, you need to have it in every chapter, and such repetition isn't efficient. So are you accepting of that?
I am accepting of it, although I have seen, perhaps it's Timaru, in their plan recently that they had the explanatory notes specifically within the chapter. And I think it's also in the How the Plan Works chapter as well, just because of the significance and the anxiety caused by what they have as quite widespread SASM mapping.
You did at your paragraph 54 pose a question, is consent needed for drilling offal holes? And I guess the other variation of that is the consent needed under earthworks for putting in subsurface drainage? And that's something that I don't know, Matt, whether you're able to assist with.
I'll have to have a look.
So, like yourself, at paragraph 65, I was curious to find out that Council has 8 full-time equivalent staff people working on consenting. I think the person has misread the question. There might have been 8 people who had contributed, but from a full-time equivalent, I doubt that there's more than one.
That was data that we got off MFE, so it potentially was incorrect.
Okay, I've got no further questions. Anything else? No. All righty. So thank you for being here today. We do want to have a look at the legal submissions that came in from Joanne. So have you managed to send those through yet?
Yes, they have been sent through.
Right. So we'd like to have a read of those and pose some further questions.
So who's reading after lunch? Who do you,
Sorry? Sorry, just one moment. Joanne, if you've just sent them through, the question's been posed, that if we take a 20-minute break now to give us time to have a look at those and then come back while all 3 of the Federated Farmers people are here and the other parties can hear your response. So would that work for you as well if we did that?
I am at the panel's disposal.
Okay, so it's, so you've confirmed that it has come through? Yeah, it's arrived, been and it's been printed off. All right, so it's now 1:15. We'll adjourn for 20 minutes to allow us to have a look at that. I think in terms of the number of questions that have been asked, I think Hokanui Runanga have probably got some issues they need to chat about as well, and some things that have been looked at over there. So it's probably a good use of time. Rachel.
Sorry, Commissioner Havel, can I just ask, will Transpower's council be invited as well this afternoon?
No.
I guess we had our time with Transpower yesterday, and we asked quite a few questions of them and had quite an exchange. And where you're aligned in your approach, we can just explore that today with you. Yeah.
All right, so we'll adjourn for 20 minutes.